The kids say good morning, y'all. Morning! Why, of course, Mama. They saw I was about to unmute and talk, so they had to bark. Not fair, I tell you. It's just not fair. Ladies and gentlemen, it's Saturday morning. I'm Lone Wolf Usul, and this is the Saturday morning court case review. And we have 2 hours full of cases. We're going to start off with Judge Stevens this morning, ladies and gentlemen. I've got loudspeakers over here, don't I? You can probably hear the music jamming, because that's how I do it. Anyway, Judge Stevens, that guy. Judge Stevens actually has a crazy case with a guy who has a massive bond. You just got to hear it. Judge Hammond, Sov Cit, enough said. Judge Ricky, evidentiary hearing, prelim. It's really interesting. It's actually a follow-up to a case we've seen before. And then Judge Eric, well, you're just gonna have to see Judge Eric. It all starts right now.
Hi. Christopher Harris. Someone asked him? Yeah.
That's the other document. Oh,
He's in custody. Where's Christopher
they
Harris?
filed a motion to increase the bond.
Christopher. He's in custody. He's in custody.
In the other case.
Okay, hold on. So if he's in custody, why did y'all file a motion to increase the bond?
You already posted a bond of 250,000, and then he got out and
But he's in custody now.
So I just thought.
So why is he in custody now? And is the motion to increase the bond necessary? I know, is it necessary?
well, he posted 250 before. I'm just concerned that he's gonna believe it needs to be higher than what it is.
What is it right now?
It's I believe 500.
Is 500? Are you Christopher Harris? Okay. Who's posting your bonds? Who posted your bond? You had a bond when you were arrested for $250,000. Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something?
My mom's size.
So it's five. So she posted 50,000. Okay. There's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000. Okay, that doesn't bother you at all? I can see you don't seem real upset about it. It would be for me.
The $50,000 bond is still good. He was arrested while he was out on bond for a new aggravated robbery. So this $250,000 bond is
That hasn't been
still
revoked yet. That hasn't been revoked.
correct.
Okay. In 25 CR 1020, Christopher Harris is present with his attorney.
Oh, let's see that.
Mr. Adams and the state's attorney. I'm looking at this indictment, which alleges that on or about July 19th of this year, you committed aggravated assault there. And there was a bond set of, looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robberies and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that all right?
That's correct.
Okay. And what's August 25th? Have you seen this probable cause affidavit?
I just got it today. Yes, I just got it today, Judge. With the motion to increase the bond.
Who set the bond on this one? Does it, I guess, a magistrate?
The 500 or the
Yeah.
50?
The new one, the 500,000.
The 500 was set by Judge Sterling.
Okay. So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting. And the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled. And so a $250,000 bond was set in that case. So, just a few weeks later, and it looks like we're talking about 5 weeks later, on August 25th of 2025, after the defendant had posted a $250,000 bond, police responded in Beaumont to an aggravated robbery and spoke to the victim, who stated he was robbed at gunpoint by 3 black males who stole his belongings as well as his Lincoln Navigator vehicle. And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont with the lights on and the engine running. And observed someone named Arthur Goolsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendants, Harris and Brandon Johnson, who were armed with handguns, lured Wilson to pick them up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? Some of you got them. You know, 3 people at gunpoint and then steal everything, tell them to run, and then shoot us. Yeah, Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had an ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? You know, when you got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And we'll put him right at the location at the time of the robbery. And so, if that's not enough, an Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry who was stolen from the robbery. Okay, there is a motion to increase the bond. Anybody else want to be heard? I've read it, the 4 corners.
Nothing from the state, Your Honor. I believe it's.
What's the defense say on this one? Give it your best shot.
Judge, I think at least from what your clerk said, my client has not made a $500,000 bond at all. And the $500,000 bond is the one that you just said was set by the woman. I believe the state said that he did make a $250,000 bond. So unless as judge, that bond has already been doubled to the 500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled, and that's something that he has not made, and it's doubling what he did make. So
Right.
I'm just asked to keep it at that 500,000.
Anything? Statements?
Your Honor, we're just asking for the other one is at 500,000. We've just asked for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, and then gets out and does this aggravated robbery, again, shooting at an individual, not much later from when the other, I think within a month.
Did you look into bro? You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That wouldn't be wise. Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it chose? Because I don't have a lot of.
No contact with complaining with witness remain in Jefferson County and 2 testifies.
Okay. So just a few weeks later, I'm sorry, this was on or about July 19 is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, then posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, so teaching the defendant commits another similar robbery, a aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious, and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So it's obvious that the conditions of bond that were set, a high bond amount, and ankle monitoring did not deter him from committing a more violent crime. So he is in custody and there is no bond. The court finds that there are no reasonable conditions that can protect this community from these bizarre, violent crime need, and for the protection of the people and to see that the Constitution works so that we can live in peace. The defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies. So and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost to the, so unfortunately to his mother who posted that bond, but that's the way the rules are. Ironically, you don't seem you don't seem too upset, but there are victims in two different situations. But there's also a victim here, your own mother, that you victimized by your actions. You don't seem too upset. I would be. I think that's just normal behavior. But there is no bond, sadly, for your poor actions, and we will set this for trial. Okay. All right. That is all.
Okay, case number, 25F00315SI, people of the state of Michigan versus Travis Wayne Cox. And counsel, if you could place your appearance on the record, please.
Yes, good afternoon, Your Honor. Mitchell Young for the people.
All right, and Mr. Cox, coming up. All right, you can have a seat right. All right, and you are Travis Wayne Cox, correct?
Yes.
All right. Okay, we are here on a careless driving civil infraction. Mr. Cox requested a formal hearing on the matter. And so, Attorney Young, are you ready to proceed?
Your Honor, yes. The people are ready to proceed. I do have a couple preliminary matters.
Okay, what are the preliminary matters?
I do believe originally the ticket was for careless driving as well as no proof of insurance. I'm not exactly sure what happened with that. I would ask that also be included, and I do believe the law allows me to amend the ticket as well to add other infractions.
There was also no ops on person. There was 3 charges.
I agree with you. Just hold on, let him finish, and then you'll be able to speak,
Yes.
okay?
So I guess at this point, the people would move to amend the ticket to add following too close, which would be MCL 257.643. And I do believe that the no ops was a warning at the time. I would just leave it at that, Your Honor.
All right, thank you. And you are right, Attorney Young. The careless driving is the first charge on the ticket, and so that's the one that's written on the charge portion of the front of my file, but I do see that the other ones are there. So it was a civil infraction of careless driving, a civil infraction, no proof of insurance, and then it was a warning on the no ops on person. And then the prosecutor's office is requesting to add, because they believe testimony will show a violation of following too close under MCL 257.643. Is that right?
Your Honor, that is correct. I do believe there may be other infractions, but I think in general that they would go to the count 1. So
I'll just make note of possible other requests. I'll cross that bridge when we get there. Okay, and just in regards to that, Mr. Cox, was there anything that you wanted to add?
Yes, ma'am. There was I went through court a couple, I think it's like the 4th time I've been here now for this. The first time I went, I was supposed to have a formal hearing. It was an informal. So then I wanted to get the police records. So we did that, and I come back again. And then we all watched it, and what was on this ticket, what didn't happen in the video, which I have on me today if you'd like to see. And then, so she said, well, just leave, and then I'll send you something in the mail. I said, okay. So I waited a couple weeks, and she sent me it was called an improper passing.
Right, I had that
2
report.
points, 3 points, something like that. So that's why I appealed it, because I didn't do any of that.
Okay.
It's proved on the video.
All right, we'll have that hearing in just a moment. And I do see that the civil infraction judgment that's in the file from the magistrate from the informal hearing does have that the court finds after hearing the defendant is responsible as amended, improper passing, and that there was a balance due $130 for that, date owed by 8/15/25. And then there was the $130 was paid as the appeal bond when the appeal was filed, and we find ourselves here today. So the court reviews these matters de novo, which means that I have my very own hearing with what the magistrate determined makes no impact on me whatsoever. I'm going to listen to the testimony that I hear today. I'm going to make my own decision based upon the testimony. And so when you appeal, it kind of voids that right to have that judgment stand, which the magistrate found that improper passing. So when I hear it, I hear everything all over again. So we go all the way back to the careless driving, no proof of insurance, and then prosecutor is asking to possibly add some things, at least the following two posts, maybe others, and we'll see if that is appropriate or not as I hear the testimony. But today is the date for everyone to present all of the evidence that they have. So if there are videos or anything like that you want me to see, now's the time for it, okay?
Yes, Judge, I was going to bring that up. It sounds like people would like to use the video as evidence. I do have a flash drive that contains all the video. I believe it also includes the body cam as well. I also have it downloaded on my computer. I don't know how the court would want that to be played in court if and when we get there.
Okay, so what we'll do is, if you can log on to the Zoom.
And share my screen.
And you can share your screen.
Okay.
That's perfect. And Diane, do you know how to do that? Allow him to share a screen. It's not too difficult.
If you want to see it up close, though, I can zoom right in on stuff.
No, we'll be able to do it this way. This is better. That way it's on the record rather than me looking at somebody's phone. It's better this way. And that way we can all kind of look at it together too. So, okay, so why don't we figure that out first? So Attorney Young will log into the Zoom, and then once he's in there,
Yes.
yeah, he should be able to permit him to share his screen. Sure.
Excuse me, ma'am. There's just one part of the video, because where he's in the far right.
Hold on.
We won't be able to see it very good.
He's gonna show whatever part of the video he wants to see. If there's a part that you want me to focus on, when it comes time for you to speak, you'll be able to tell me what part you want me to focus on. But he can show me the entire video if he wants to.
Okay.
Whatever everybody wants me to see, we'll look at it.
I have two videos, so also just to let you know. One video is of his reaction, and one video is of the vehicle.
I think there was a body cam and a dash cam.
Yeah, a dash for him, and then there's actually a 360 cam, but they only gave me two for some reason.
Well, if we'll get to that part when we get to that part. If there's another video after the prosecutor is finished putting on his proofs, if there's something else that you want me to see, then we'll talk about it when we get there, okay?
I know I've had an issue before with Zoom and with like the microphone doing like a double speak before. I don't know if that's going to be an issue.
If you mute yours,
I should mute
that
mine.
should take
Okay.
care of it.
Okay. All right. So I'm logged in. Oh. Do you want me to share my screen right now, or do you want me to just wait? Okay.
You know, I just want to make sure that we have it up and rolling before we get started. Things will go a little smoother. All right, while we're doing that, I just want to make sure one more time, Mr. Cox, we've talked about this once already, but before we get started with the hearing, I should go over it one more time. This is a civil infraction, and so you aren't entitled to have the public defender's office appoint you counsel in these matters, but if you had wanted to be represented by an attorney, you certainly could have hired an attorney to represent you. But as I understand in our prior conversations, you intend on representing yourself, correct?
Yes, ma'am.
Okay. There we are. All right. Looks pretty good. All right, we're set. All right.
Could we read this off before we watch it, what I did? Not the charges, but what he said that I did?
He's going to testify to all of that.
Okay.
He's gonna testify to all that. You'll have the opportunity to cross-examine him. Okay? All right, and so I will permit the parties to make a brief opening statement if they want to. If you don't want to, then that's all right. We'll get right into the testimony. And we can take that off for right now and then pop it back up when we need it. All right, Attorney Young, did you want to make a brief opening?
Yes, Judge.
Go ahead.
Thank you, Judge. Mitchell Young for the people, and I'll just keep this brief. I do have Trooper Conkergood here today, and he will be testifying. I do believe, based on his testimony, that by preponderance of the evidence that the defendant here was careless driving. I think it was a culmination of several different infractions in the way he was driving. I think he was following too close. He passed on the right, and I don't believe he did that in a legal manner with other cars around. I do not believe he used a blinker. And I think everything that happened there culminates to careless driving. I don't believe his distance from the vehicle in the left lane gave him adequate distance to stop if something were to happen. And I'll leave it at that, other than the fact that we will be watching the video too, of the dash camera, Trooper Conkergood that day. Thank you.
All right, thank you. And Mr. Cox, did you have any opening that you wish to make?
No, ma'am.
All right, thank you. All right, then you may call your first witness.
Thank you, Your Honor. The people will call Trooper Chad Conkergood.
Okay, Mr. Conkergood, or Trooper Conkergood, if you want to come up to the podium, I can swear you in. Podium? Yeah, come up here first. Oh, you want to stand? Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do.
All right, you can come on up and have a seat. Let's stand then. All right, go ahead.
Thank you, Judge. Good afternoon, sir. If you could please state your first and last name and then spell it for the record.
Chad Conkergood, ChadConkergood.
Thank you, sir. Where are you employed?
Michigan State Police.
How long have you been employed there?
A little over 10 years.
I'm going to draw your attention to April 25th of this year, 2025, sometime in the morning. Were you working on that date?
I was
And what were you assigned to do that day?
directed traffic enforcement.
And where were you working at? Do you recall?
I-69 would have been near Genesee Road.
Did something happen on that date that caused you to be in this courtroom today?
Yes,
Did you make a traffic stop?
I did.
And where is the traffic stop located at?
I believe it was I-69 near Genesee Road.
Okay, and is that in the city of Burton,
It is,
Genesee County, state of Michigan?
correct.
And I'll start with this. Did you make contact with the person that you stopped?
I did.
If you saw that person again, would you recognize them?
Yes,
Is that person in this courtroom today?
he is.
Can you please point at and describe where he's seated and what he's wearing?
He's at the defendant's table. He's behind the podium, so I can't see what he's, looks like a black suit.
May the record reflect the witness has identified the defendant.
We should probably refer to Mr. Cox as a
I
respondent.
responded. I'm sorry, Your Honor.
I may have said it too. A little bit have it there, but all right, go ahead.
Thank you, Judge. Was there anybody else in the car that
No.
day? So why did you stop the respondent?
It was a series of moving violations, which I took to be careless driving.
So explain to me what you saw, and I guess first, where were you at when you saw it?
I was traveling in the right lane on westbound I-69.
How many lanes are in westbound I-69 where you were at?
3,
Where was the respondent?
the left lane.
So what you said you saw infractions, what did you see?
So I was operating, it's vehicle 3042. It's a semi-marked Silver Explorer, traveling below the maximum speed limit there. I was traveling approximately 55 miles per hour in the right lane. There's a vehicle in the center lane. I believe it was a white SUV. And then in the left lane, there was a red or maroon van followed by a red or maroon Chrysler 300. As the Chrysler 300 caught up to the red van, it got approximately 25 feet behind that vehicle. Once both vehicles passed that center lane, the vehicle that was in the center lane Mr. Cox conducted a lane change. I did not observe a signal at the time. It did not appear he had sufficient distance in between the vehicle that he was moving in front of. He then slowed down next to the red van that was in the left lane. He then proceeded to speed up, execute a left lane change. Again, I did not observe a signal. And again, he did not appear to have sufficient distance between his vehicle and the vehicle that he was passing.
Now, you said you were going 55 miles an hour. Do you know about how fast the respondent was going?
I don't.
Do you recall, I know you testified to a few other cars around, and we'll see the video too. Do you recall about how many cars were around when you saw the passing?
The immediate vicinity, it was the red van and then the SUV in the middle lane. I believe there was a gray SUV in the center lane that was a considerable distance in front of those vehicles.
And did you have a dash cam on your vehicle that day?
I did.
And did you submit that video to prosecutor's office at some point or give it to somebody at some point, or how does that work?
So we have WatchGuard as our in-car camera system. It saves to the cloud, and then we're able to share an export file, which allows other people to see the video.
Sir, I'm going to be showing you, I suppose, what is people's proposed Exhibit 1, a dash cam video. And I'm going to share my screen. Now, this video is paused right now. Do you recognize this video just from the screen grab here?
I do.
Is this an accurate depiction of your dash cam on the date and time that you've testified to already?
It is.
Your Honor, I would move for the admission of this video into evidence.
Any objection?
No.
All right, no objection, then the proposed exhibit number 1, the dash cam video will become exhibit number 1. Go ahead.
I would also respectfully ask this court permission to publish the video and or play it.
Permission granted.
Okay, I'm pressing play now. And I guess I'm going to pause it real quick. I'm sorry. Trooper Conquer Good. What vehicle was the respondent driving?
Chrysler 300.
Is that the Burgundy? I think it's described as Burgundy or
Maroon red. Yep.
Pressing play again.
Your Honor, would it be appropriate for me to stand up?
You may, yes, you may. It's hard to see from there.
Seems to be glitching a little bit. Ooh. Judge, I'll just stop it there. If that completes that. I will say it looked like it was glitching on the court screen for some reason, but it looked like mine was flowing better if the court want to see the video on my computer. Or
Was it still an accurate depiction of what was happening?
or
Did we miss anything?
it appeared to me it was just like stopping and starting a lot, but otherwise, yes, I would say it's an accurate depiction. It just doesn't flow.
I'm fine with it as long as I saw everything that was on the video. I'm okay with that. Okay. So you can go ahead and have a seat for now. Is that you're stopping the video now?
Yes, Judge.
Okay.
Trooper Conquer Good. Did you have a visual of this vehicle prior to what we see on the dash cam with the vehicle in front of your vehicle?
Basically, I picked it up as it was passing my patrol vehicle.
So you didn't see the vehicle traveling before that moment?
I did not.
One moment, Your Honor. I have no further questions at this time. Thank you.
All right, thank you. Do you have any cross-examination for the trooper? Just stand at the podium if you want. If you have any questions. If you don't,
I don't really have any questions for him, but I want to say something about the video.
you'll get your chance to do that.
Okay.
Right now is just, do you have any questions for the trooper?
Numbers.
No? All right.
I have nothing further, Judge.
Then, sir, you are excused as a witness. You can go ahead and step down and take your seat. Anything else, Attorney Young?
Your Honor, with that, the people would rest with the admission of that video.
All right, people rest at this time. So, Mr. Cox, now it's over to you. If you would like to testify yourself, I'm going to have to swear you in. You can stand here at the podium so I can swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do.
All right, and then because you're representing yourself, Attorney Young, do you have any problem with Mr. Cox just sitting at the table here rather than getting into the witness stand? Attorney Young?
I'm sorry, Judge.
Do you have any problem with Mr. Cox sitting at the table instead of going to the witness stand?
I have no problem with that,
Since he's
Judge.
representing himself, it's easier for me that way. All right, let's stop the screen share.
Do you mind keeping the screen share up?
Are you gonna want to play it right now?
Yes, ma'am.
Okay, all right. Do you want to play it from the beginning?
Yes, ma'am.
Okay, so if you want, and I'm gonna ask Attorney Young to help you out a little bit here. So he'll play the video from the beginning. If you want it stopped at a specific time, say stop, and he'll stop it there because what I don't want is that playing and you talking at the same time.
Okay.
Okay, so you want to play it from the beginning?
Yes, ma'am.
Okay.
Play it.
Yes, hit play, please.
Oh, yeah, his videos.
Can I just use my phone and show you? That's really bad.
So you're asking for it to
It's
stop?
was right by the spot to eat. Yeah.
I just paused it. It was
It's like someone manipulated it or something.
judgment, if I may.
Why don't do this? Do this. Mr. Cox, show the video that you have on your phone to Attorney Young, and then once you show it to Attorney Young, he doesn't have a problem with me looking at it, then I'll look at it on your phone.
It's working on my laptop. I think it's just the sharing. I do have a bigger screen if it helps.
It's in perfect speed on this phone. If you'd like to take a look.
Just look and see if it's the same thing. If it's the same thing, it doesn't matter where I look at it on.
It's exactly the same.
The same 951. Yeah, that's fine.
Right.
That's all fine.
And because there wasn't under the breath accusation of the video being manipulated, what I'm gonna do is I'm gonna look at what's on his phone and then I'm gonna look at what's on your computer.
It's just,
All right, then you're gonna, I know, but
This
that's
could
a
be-
big allegation to make against the prosecutor's office, so we're gonna lay that to rest. Don't go back to the podium, please, you can't.
Certain spots so you can see it. You'll just first look at the length of my car between the two vehicles on that pack. And then notice no brake lights light up when I make the lane change 'cause I didn't cut the person off. And I did not get in front of the red van and brake check them like this ticket says I did. All these things are on this ticket.
Okay, that's part where I see your card, you're behind the red van. You change lanes. Do you want me to stop it?
Here, yeah, just let me see it real quick and I'll stop at certain points so you can see what I'm talking about.
Well, the problem is we can't, this is inappropriate. You
I
can't
know
be this close to me,
but I don't know
so.
what's wrong with this video. It's very hard to do, so shaky. So right here is where I'm following the van. And it says I'm
Back,
less
Gotta go
than
back.
one car length behind that
I
van.
say something you don't like,
I
yeah.
have several car lengths behind that van. And then I'll go to the next spot. My
Okay.
car was
You
set
know,
three
I've
car
seen the
lengths.
whole video though. I've seen the whole video
Right.
though, right? So you can stop it at points if you want to. But the continuity of the video, that is important to see.
Right.
Okay.
Right, but we
So
need,
you get a lot closer to that van. It's okay. Show me what you want. Show me what
we
you want me
all
to
need
see.
to really be able to see this video clearly on this. I don't know
I'm
why.
looking at it on your phone. Keep showing it to me. What else do you want me to see?
Okay, so the ticket says,
We're talking about the
Driver,
testimony. I don't care. Like I said, it doesn't matter what the magistrate did. It doesn't, I don't care what that says. I care what he said on the stand. That's what I care about.
That's what he said. Here, he typed it with his fingers.
What, did he say it right here?
He didn't say anything. He just got asked a bunch of questions that were obvious to the situation.
What else do you want me to see on the video?
All right, so I just need you to know what this says. I know you probably read it.
I have.
I'd like to refresh your memory on what he said that I did, not what they said that I did.
Attorney Young, do you mind if I see what he's trying to show me?
I have no problem with the ticket. That's fine.
All right, go back. Go back. Well, this is
don't
the
get
problem.
railroaded
I'm
here.
frustrated because you don't understand how the process works, and when you don't stop, listen, here's one thing you definitely do not do. You do not talk over me. That does not happen, because if you start talking over me, one, we have a problem with the record, and you want a good record because you already appealed this once, and you might want to appeal it again. So you want a good record. So do not talk over me. Second, it's just the way the court works. You don't talk over the judge, because I could hold you in contempt and I could put you in jail for it, and I don't want to do that. So you gotta not talk over me, okay? Here we go. This is the ticket.
Yes, ma'am.
This is the same ticket I have in the file. Driving approximately one vehicle length behind vehicle in left lane, cut off vehicle in middle lane to get around and cut off vehicle in left lane and apply brakes. Expired insurance stock. No ID with him. Secretary of State ID. Same thing I have in here. Okay, you can take that back. Going back. Okay. Now, did you want me to watch the rest of the video on your phone?
Yes, ma'am.
Just bring it up and just let me watch the video, and then you can tell me, you can take your phone back and you can tell me what points you want me to focus on. Going back. Okay. So I'm watching the video again. It's the same video that was up there. It just does have a little bit better of a
All right.
to it.
Oh, when I passed the car on the right, you'll see it didn't apply brakes because I didn't cut it off. You can zoom in as well. I didn't slow down next to the van. I didn't cut off the van in the far left lane. I had several car lanes when I came over. I'm in a full-on race car, racing everything. So I maneuver quicker, but I didn't cut anybody off. I came over super slow.
Somebody is calling you. I'm going to hit the
Okay.
reject button. Okay, so come back and get your phone. Podium. So that where I stopped watching was the same point where I stopped watching here, which is where the vehicle is pulled over. Was there anything else that you wanted me to see from that camera?
No, ma'am.
No. Okay. Was there anything else that you wanted to testify to as to what your interpretation of the events were?
The only time I'd let the camera see again is if we all start having a dispute and I need to prove it again. Because it seems like every time this happens, no matter what I do and say or show, I'm the bad guy. And I did nothing wrong. I've been in trouble tons, never lied in my life. For anything I've done, I served my time. I've been in tons of trouble. Multiple felonies, multiple convicted violent felon. I've done it all. I'm not lying about this. I didn't do nothing wrong. That's why I'm here. I've never appealed anything my whole life. Ever. I don't want to pay money to people for nothing. But this isn't fair. I shouldn't be having points on my license for something that I didn't do. I didn't cut this guy off. I didn't cut this guy off and brake check him. I went real slow and then poof, right past him and I was gone. And here he comes.
Okay. Anything else?
No, man.
Okay. Attorney Young, did you have any questions for Mr. Pax?
I do.
Okay, go ahead.
Sir, isn't it true that you flipped off the driver as you passed them? Is that not true?
Objection. It's hearsay.
Response to the hearsay objection?
I think it's a part of the opponent's statement. And I think, I honestly, I do think it's a prior statement. Subject to crossing.
Well, you gotta let me rule on the first objection first. Hold on. Right, and that is true. There's an exception to the hearsay rule. If the party opponent does or says the thing themselves, then it's admissible, and so you need to answer the question. Answer the question.
Do what now?
Answer the question.
What was your question again?
repeat
Is it not true that you flipped off the driver that you passed on the
I
right?
did. I did.
No further questions, Judge.
Judge. Could I speak if I could?
No, there's no question posed to you at this time, so you-
Judge, I'm sorry if I may ask one other question. Only if the court allows me to.
you're going to be able to give a closing argument. You're going to be able to give a closing argument, but you can't just freely speak. We're going to talk about this in a minute because I see what the issue is. If you have another question, you may ask the other question. What was the question?
Mr. Cox, is it true that you did not have insurance on that date?
No, it is not.
It's not true?
No, it is not. Car has insurance in the winter when it's parked in the garage.
Did you provide a proof of insurance to the officer?
Last court date, I showed him.
Did you do it when you were pulled over on
No, I had an
April
expired one.
25th?
I had an expired one, and as I kept looking, he was in a hurry. As I kept looking, I found it was in the car. My bad for having more than one in there. I thought I had the correct one, but that car's never ever in its life been uninsured, unregistered, on anything. It's a full-on race car worth a lot of money.
So your testimony today is that the vehicle was insured on April 25th?
Yes, sir. Full coverage.
I have no further questions, Judge.
All right, thank you. Okay, since the issue of the insurance was just brought up, was there anything else, Mr. Cox, that you wanted to say about the insurance?
No, ma'am.
Okay. All right. And anything else by way of evidence or anything of that nature, Mr. Cox?
Yes, ma'am. So, can I speak to him?
No, you cannot speak to him.
Okay, so when I come here, the last court date I was here,
Hold on. I just need testimony about the event in question. We don't talk about
that's what it
anything
is.
else.
It's all gonna be part of
The
it.
event in question,
It's all the one thing, the event. It's all everything.
no, it's not. We're talking about when you were pulled over on April 25th, 2025. I don't want to hear about any interaction between you and the attorney. It is
Okay.
irrelevant to my decision about whether or not you violated.
Flip someone off.
Remember what I said about talking over me?
Sorry.
If you do it again, we're gonna have a problem. Listen, look at me. You just need to listen to what I'm saying and then respond. Don't think about what you're going to say while I'm talking because that's how you talk over people. So just listen, breathe, and then respond. Okay? Was there anything else you want to say?
No.
Okay. All right. Then both parties having rested, the parties may make closing arguments if they wish. Attorney Young, was there anything that you wanted to say?
Yes, just briefly. I do believe, based on the video and the testimony, there's a couple infractions that occurred. And I'll start with the following too close. MCL 257.643 states that an operator of a motor vehicle shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of the vehicles and the traffic and the condition of the highway. So we have here respondent driving on the expressway. People are driving fast on the expressway. Trooper Conker testified, I believe, to about 25 feet. I watched that dash cam, albeit it's a little hard to tell because of the angle, but it appears to me that the defendant was getting closer. The respondent was getting closer to the vehicle in the left lane, did not use a blinker. Whether or not a car braked or not, I don't think is dispositive as to the passing because MCL 257.637 states, it says a lot in there, but I think relevantly it says the driver of a vehicle may overtake and pass another vehicle upon the right only under conditions permitting the overtaking and passing in safety. I think here, I don't think the actions here were in safety. There were other cars around. He quickly passed on the right and then quickly got back over to the left. He's not keeping to the right, essentially. I think the culmination of all that does show that he was careless driving, which a person who operates a vehicle upon a highway in a careless or negligent manner likely to endanger any person or property, but without wantonness or recklessness is responsible for a civil infraction. I think here we're on the highway with cars around. It's not like there was only 2 cars on the expressway at the time. I do believe by preponderance of the evidence, this was at minimum careless driving. And also not following too close, improper passing. And I will admit, we didn't hear much on the no proof of insurance. But we did hear he didn't present it. It sounds like he did not present it to Trooper Conker Good. And I'll leave that back, Your Honor. Thank you.
All right, thank you. And Mr. Cox, is there anything you would like to say by way of a closing argument
About the case or about what's happened?
about the case?
No.
Okay, so now it is time for me to give my ruling on the matter, and everybody please remember, when I give my ruling, nobody speaks. It's my turn to speak and only my turn to speak. The burden in a civil infraction case such as this does lie with the prosecutor's office to show by a preponderance of the evidence whether or not these civil infractions have indeed taken place. Mr. Cox, I do not in any way think that you are a liar. And I hope that you know that when we have hearings like this, it's not a question of whether or not people are necessarily lying or not. Sometimes people are, but that's not necessarily the question. It is very possible for you to be mistaken about what you did and about what the law is. And if the question was whether or not your actions were intentional and or reckless, you would be facing misdemeanor charges. You are only facing civil infractions, which carry no penalty of jail time. Just a civil infraction comes with a fine. And the reason they're civil infractions as opposed to misdemeanor charges is because the trooper who issued you the ticket and then the prosecutor's office who represents the Michigan State Police have determined that they did not believe that your actions were wanton, willful, reckless, intentionally negligent. That's the, well, negligent is careless driving. So, but they didn't find that your actions were so bad that you deserve to be charged with a crime. It's just a civil infraction. And so I think that part of your problem in coming in here is that you think that people are accusing you of doing these horrendous things when they're not. What the trooper is saying is that he witnessed you disobey traffic laws. And there's a video that shows you disobeying traffic laws. I agree that you disobeyed traffic laws. Your interpretation of that video is off because we are seeing different things. You are far too close to that car, far too close. And I agree. It looked to me like it was closer than 25 feet, but you are far too close to that car. It was dangerous. And the way you weaved in and out, that is dangerous driving. Is it reckless? No, I wouldn't describe it as reckless, but I would describe it as careless. Definitely careless. And the car behind you, when you're following so close to somebody and then you go around them, it doesn't matter if they put on their brakes or not. What matters are your actions, not their actions. Now, if your actions had resulted in somebody getting hurt because they had to slam on their brakes or something, you'd probably be looking at a higher charge. That's why you're not looking at reckless driving. That's why you're looking at careless driving. Were you following too close? Yes. Were you carelessly driving? Yes. You didn't have proof of insurance. You had insurance. Again, that's why it's not a no insurance. Having no insurance. Having no insurance is a misdemeanor charge. Having no proof of insurance is a civil infraction. And so that's why it's a civil infraction, no proof of insurance. And your testimony was, did you have proof of insurance? No. Did you flip off a driver? Yeah, you said you did. Is that a civil infraction of any kind? It's not. It's not very nice, but I'm not going to fine you for that or anything like that. I don't care. I don't like it. I wouldn't like it if somebody flipped me off, but I don't care. I'm not going to hold you accountable really for that. Just tell you at least try to be nicer to people. So I do find that there is preponderance of the evidence, and a preponderance of the evidence, in case you did not know, is one of the lower burdens in the we're not in the criminal law system, but just in the system in general. It means that the prosecutor's office basically just have to show that they are more right than you are. It's not, reasonable doubt is way up here in a criminal case where you have the penalty of possibly going to jail. It's a big difference. In a civil infraction, it's not that much. They just have to show that they are a bit more right than you are. And they've shown that by far. They've shown that video by far shows that you were carelessly driving, you're following too close, and the testimony shows that you didn't have proof of insurance, right? So I'm going to find you responsible for those 3 civil infractions. The 3 civil infractions carry, let's see, careless driving has a $205 fine. Following too close is $130 fine. And having no proof of insurance, you are, thank you, Debbie. You are $165 for the no proof of insurance. Now, I give everybody 30 days to pay their civil infraction fines, but you have a little bit more than just one fine to pay. So it comes to a total of $500. How long will you need to pay that? I will give you longer than 30 days if you ask for it.
I'm probably gonna pay it today because I'm gonna appeal.
Okay.
Again.
Well,
Now,
you've
if I
already,
go to this court again, do I have to get like a criminal charge to see someone else? I can't do this court no more. He threatened me in the courtroom last time I was here. If you take this, and this is what happened to me. Now I have even more charges. That's crazy.
right, so if you appeal, it will actually go to a different judge because this is now a formal hearing. You'll go to an appeal if you decide to appeal it. You've already paid $130 to have this hearing because that's what you had to do from the magistrate's hearing. So if you want to pay today, I'll write pay today on there. Is that what you want to do?
No, I don't want to pay you anything. I'm getting, this is
Let's not be cute.
Unreal.
Let's not be cute.
onward.
Do you want time to pay this or not?
No. Yes, I do. 30 days.
Okay, all right. I will give you 30 days to pay your civil infraction fines. And is there anything else? You may appeal within 7 days of this judgment. And yes, you are going to have to pay the appeal bond.
Do I get my 130 back to apply to that?
It gets applied. It'll get applied. All right. Is there anything else from you, Attorney Young?
No, Judge, thank you.
Anything else from you, Mr. Cox?
Yes, do I have the same prosecutor next time too?
Those are not questions that.
Well, you guys all conspired against me in the room I listed last time, and this is what's happening to me in this place. You got people up here.
You also
talking about
alleged
Pirate
that,
Day law.
stop speaking. You also alleged that the video was altered. Now everyone's conspiring against you. Mr. Cox, I'm sorry that you think that, but it's just untrue. Once again, your interpretation of the facts, they're just wrong. You are misinterpreting what is going on, and I hope that you talk to an attorney. I would love for you to
I
talk
don't
to
need
an
an attorney, but these are my charges that were he gave to me, the
Stop.
guy that was there.
Stop.
You guys.
This hearing is over. All right, thank you, everybody.
District Court of Greenwood County, Kansas, case entitled State of Kansas versus Robert Lee Williams. It's case number 2025 CR 74. Mr. Williams appears at the Greenwood County Courthouse's Zoom location. Chris Ambrose as defense counsel. Jill Gillette as Greenwood County attorney. This matter was scheduled to come before the court this morning for a hearing on a motion to suppress evidence. Is the state ready to proceed here?
We are, Your Honor.
And I trust the defense is ready to proceed, Mr. Ambrose?
Yes, Your Honor.
All right. Do you intend to call a witness, Ms. Gillette?
Yes, Deputy Blake Fisher should be logged in.
All right. All right. Deputy Fisher, if you can join us fully with audio and video. All right. At this time, the court will resume proceedings in the Williams matter. All persons appearing as before. We've also been joined here on this Zoom meeting by Deputy Blake Fisher. It's my understanding, Ms. Gillette, you're going to be calling him as a witness.
We are, Your Honor.
Fisher, if you'd raise your right hand, please. You do solemnly swear that the testimony you are about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God?
I do.
Very well. You may question the witness, Ms. Gillette.
Would you please state your name for the record?
Deputy Blake D. Fisher
And how are you currently employed?
by the Greenwood County Sheriff's Office
How long have you been so employed?
since December of 2019.
And were you on duty on March 1st of 2025?
I was.
And, oh, sorry, yes, March 1st of 2025. I thought it was May 23rd. I think the motion to suppress had the wrong date listed at the top. Were you on duty on May 23rd, 2025?
Yes.
Where were you dispatched to?
US Highway 400, about the 320 mile marker in Greenwood County, Kansas.
And were you dispatched for something in particular?
Yes, there was a individual flagging cars down.
Did you then proceed to that area?
I did.
Were you equipped with a body worn camera and your vehicle equipped with a dash cam?
I was.
And did you provide a true and accurate copy of that to the state?
I did.
And is it an accurate depiction of the events of the night of Friday, May 23rd, 2025?
It is.
And Your Honor, we would ask to admit the dash cam of Deputy Blake Fisher into evidence as State's Exhibit 1.
Relevance?
It will show the encounter between them and how quickly it changed from a safety stop to a probable cause detention.
Has this previously been provided to the defense?
It has, Your Honor.
Very well. Any objection, Mr. Ambrose? Mr. Ambrose? Okay.
Sorry
unmute
about that.
yourself, Phelps.
No, Your Honor, no objection.
Very well. Court will admit the dash cam into evidence, and I trust you intend to share screen and play that at this time.
We will, Your Honor. It's going to start about the point where Deputy Fisher gets close to seeing the vehicle. There's no sense in watching him drive for like 3 miles, 4 miles.
Very well, Ms. Gillette.
Hey, Sheriff, I'm 23, 400 eastbound at the 323. It's gonna be, I believe, Colorado. How you doing?
Sure, 40 and 165 and 17.
Takes me a second to switch audio, Judge. Deputy, did you ask him for a driver's license check?
Not at that time, no.
And were you just discussing with him? What were you discussing with him?
What was going on? He said that he had ran out of gas.
Okay. Besides calling in the license plate to identify the vehicle you were out with, was there any other identification things that you had done?
No.
And at that time, when you first stopped, what was your intent?
To ensure that everybody in the vehicle was okay.
And is it customary for you to turn your emergency lights on when you're out with a stranded or broken down vehicle?
Yes, especially on a busy highway for safety purposes.
And we've already identified that this was Highway 400. What's the significance of Highway 400 and its busyness?
Very busy.
And is it a highway there's lots of accidents on?
There is.
And is mile marker where he was that within the bounds of Greenwood County?
The 323 mile marker, which was in the bounds of Greenwood County, Kansas, yes.
And when you approached the vehicle, what was the first thing you noticed about it?
I was able to smell a strong odor of marijuana coming from within the vehicle. I was also able to tell that the two rear passengers, I say rear and not back seat because there was no back seats up, were not in any safety harnesses.
And what was unusual about the back part of the vehicle?
It had a mattress laying across the rear of the vehicle.
And in the video, I don't know if the judge was able to pay attention to it. What direction was the female adult passenger facing?
She was sitting behind the front passenger seat and she was facing the rear.
Were you able to illuminate her face with your flashlight?
I was.
And were any of those be a traffic infraction, a probable cause, or an issue that would have changed this stop?
I don't understand your question. Can you rephrase? I'm sorry.
Was there anything that you noted about the vehicle immediately that would change this stop from a welfare stop to something else?
The odor of marijuana when I approached the vehicle.
Okay. And would there have been any traffic violations as well?
The adult female passenger and the juvenile female passenger weren't in any safety harnesses.
And did you then later conduct a probable cause search of this vehicle?
I did.
Your Honor, I will pass this officer to the defense.
Do you have questions for this witness, Mr. Ambrose?
Yes, Your Honor. So Deputy Fisher, you had indicated that you had smelled the odor of marijuana coming from the vehicle. Is that right?
Correct.
At what point in this interaction did you begin smelling the odor of marijuana?
I smelled it as soon as I got out of my car. The odor was that strong.
Did you write an affidavit in this case?
I did.
Do you have a copy of it with you?
I do.
Okay. Would you be willing to look at page 2 of that affidavit for me?
Okay.
Do you have that?
Mm-hmm.
Okay. Can you read the third complete paragraph down on page 2 that starts with "as I was standing"?
Standing at the rear driver's side window, I was able to smell the odor of marijuana.
So, and this is the is this the rear driver's side window of the vehicle that you're associating with the defendant?
Correct.
Okay. Do you mention anywhere else in your report noticing the marijuana odor before that point?
No, I smelled it when I got out of my car, but I confirmed it when I got to the rear driver's side window.
Why didn't you put it in your report before that?
Because it wasn't necessary.
Next, you discussed this issue of passengers in the vehicle not being in seatbelts and one of them facing the rear as you are up approach to the vehicle, correct?
Correct.
But when you arrived here, the vehicle was stopped and parked on the side of the road, correct?
Correct.
So did you ever see this vehicle moving with the passengers in it or no?
I never saw it moving, but the front passenger seat was completely obstructed where nobody was able to sit in it. And like I said, there was a full mattress that was laying down across the rear of the vehicle. So it pretty well indicated that there was never a seat belt or rear passenger seats used at all.
And how far into this encounter, were you able to make that observation?
Right when I walked up to the rear driver's side window.
So was that, let me go back a little bit here. I think we saw in the video that, the individual, that you've identified as Mr. Williams, approached your patrol car as you pulled up behind the vehicle, correct?
Correct.
And if I'm misstating what your earlier testimony is, tell me, but it's my understanding that he came up and told you that they had ran out of gas and some folks were helping him get more gasoline, correct?
Correct.
Okay. And so were you able to note, from that location anything about, from where you were at that point, had you noted anything about, anything involving the passengers in the vehicle and seatbelts or anything like that at that point?
I was able to see the passengers somewhat, but I wasn't able to tell if they were in safety restraints or not.
Okay. No further questions, Judge.
You have additional questions for the witness, Ms. Gillette?
Deputy, is this testimony consistent with your testimony at the preliminary hearing that was held in front of Judge Webster
Yes, ma'am.
on July 11th, 2025?
Yes, ma'am.
Do you remember if there was any weather conditions that day that would have helped or hindered your ability to smell the odor?
I don't believe there were.
All right. I think that's all I have, Your Honor.
Anything further along those lines? Mr. Ambrose?
No, Your Honor.
All right. Very well. Does the state have additional witnesses to present?
The state does not, Your Honor. The state will rest.
Mr. Ambrose?
Just argument, Judge, no witnesses.
All right, very well. I know the state has the burden. The court's quite aware of that, Mr. Ambrose, but I want to understand exactly what the theory is behind this motion to suppress. What are you complaining of regarding the law enforcement conduct in this case?
So, Your Honor, I think at the beginning I don't think that we're fighting about the fact that law enforcement can do a welfare check on the side of the road for someone. However, it's my understanding that as the law stands currently, once the officer has been verified that the individuals on the side of the road are okay and they don't need anything, law enforcement has no motivation or legal prerogative to continue that interaction. So our contention is that upon Mr. Williams approaching the vehicle and speaking with Deputy Fisher, that Deputy Fisher's role in the welfare check should have completed at that point. Now, we do have some dispute here regarding the odor of marijuana. That Deputy Fisher's testimony was that he smelled the odor of marijuana initially. However, as we went over in the affidavit during his testimony, he doesn't reference the smell of the odor of marijuana in the affidavit until he approaches the vehicle. And at that point, he says he's able to smell the odor of marijuana. Now, he's testified today in a prelim that he was able to smell the odor of marijuana upon exiting his car. However, that's inconsistent with his statement in his report. So our position is that because of that, he extended the scope of his welfare check illegally and unconstitutionally, and all evidence that was gathered as a result of that should be suppressed.
All right. It's the court's understanding that part of the rationale for allowing an officer to do a public safety investigation, in other words, to determine the welfare of a driver and its occupants. Would you agree?
Yes, I think that the officer's allowed to stop and check, and then once they have been made aware that things are okay, they're supposed to be done with that at that point.
Okay. All right. So
in basic,
I guess I just want to understand, is it your position that Deputy Fisher had no right to check on the welfare of the occupants of the vehicle, but since the driver came back to his car, that precludes him from checking on the welfare of the occupants inside the vehicle?
I believe that my position is that, in the position of the defendant, is that the goal of the officer during a welfare check for a stranded vehicle is to affirm that the stranded vehicle has the means to be okay. And he's not out there, it is late at night here. He's not out there in the
But isn't it
middle of the
about
state.
people rather than the vehicle? Isn't it about people to check on the welfare of persons? In other words, the driver and any possible passengers that might be in that vehicle to make sure that everything's okay. He's not there to check on the vehicle, is he? He's there to check on the welfare of people. And wouldn't he have to necessarily, since they didn't all get out of the car, wouldn't he necessarily have the right to just make sure that the passengers inside the vehicle were okay?
Our position is that the discussion that was had with Mr. Williams at the beginning of the stop was sufficient to meet that obligation, and that as a result, everything else should be suppressed.
Did any of the officers' actions detain the vehicle and its occupants for any period?
Under the basis of our argument is that the actions. Sorry, Judge, I'm trying to make sure I say this the right way here. Our contention is that by the actions of Deputy Fisher, he transitioned this from a.
Mr. Ambrose, just freeze up. I heard you say transition.
I believe we're.
Mr. Ambrose, and then you essentially froze.
Okay.
I don't know what's going on with your internet, but Ms. Gillette, you're still with me?
I'm here.
Mr. Williams?
Yes, sir.
I think that's Mr.
I think the problem is only on Mr. Ambrose's end. I need him back, even if he has to get out and rejoin.
Your Honor, I believe we're back. I'm sorry about that. It's a hotspot I've used forever and I've never had problems before.
All right. You had talked about when the stop transitioned, and then that's when you got cut off.
Okay. Yes, Your Honor. So defense's position is that the need for a welfare check was properly addressed with the discussion with Mr. Williams. And as Deputy Fisher approached the vehicle after that, everything else as a result of resulting after that, any evidence gathered at that point should be suppressed, as it was an illegal extension in transition from that welfare check, going from a welfare check to a criminal investigation that was not appropriate.
All right. Mr. Lett, I don't certainly want to take words out of Mr. Ambrose's mouth and misconstrue them, but it's my understanding Mr. Ambrose's position is, on behalf of his client, that the officer couldn't get out of his car and do anything. That once he was told by Mr. Williams, who approached the officer's vehicle, that they had gas on the way, that he was just supposed to drive off. Your response to that?
That's not correct. So officers who are conducting safety stops, and we just recently had the Moran Espinoza case come down, which I provided the court, as well as some numerous case law that have come out. Even Ellis itself, that the defense quotes, says they may not lawfully extend the welfare check by running a warrant check on an individual unless there are some other circumstances support prolonging the check and converting it into a detention. Officers are allowed to get out. They're allowed to talk to them, assess the situation, make sure everyone in the vehicle is okay. They're allowed to render aid while they're there. There's numerous cases that talk about it. The Thompson case is one. Thompson is State v. Thompson, and the site on that, and I'm happy to send it to the court and Mr. Ambrose, is 284 Can 736 It's 166 Pacific 3rd, 1015. That case is from 2007. So when there is a safety stop, it is considered a detention of the defendant. That detention is the one where the officers are there to make sure everything's okay. And there's a little bit of a test, you know, are they able to move freely? Can things get worse? Is there need to be protection for the public for a stranded car? So often when cars are on the side of the road, if they're clear off into the grass, we still put tags on them or secure the vehicles, make sure that there's no one in them. 400 is a dangerous highway. Deputy Blake Fisher talked about how busy it is. Our officers often stay as long as there are individuals in those vehicles with their lights on to let approaching drivers know that there could be people in or out of the vehicle. In this case, the defendant was out of the vehicle flagging people down. That is the call on why he was there, why Deputy Fisher was there. A pedestrian on the edge of Highway 400 is extremely dangerous. That is a spot, and you could tell by the road next to it, and I'm happy to put it back up, that the dotted lines are converging for the end of the passing lanes. So he was right there on the edge of a passing lane area. It is places where people often speed. 400 is dangerous. 99 North and South are two of the most dangerous intersections this side of Wichita. There are so many numerous accidents. We have deaths routinely. I only see the ones that end up with crimes attached to them because there's so many. I couldn't even look at all of them. It would take a day every week just to go over all the accidents on 400. In order for an officer to go beyond the voluntary encounter or public safety check and detain a person for further investigation, they must have reasonable suspicion. Reasonable suspicion isn't probable cause. It's a much lower standard. It's just a thought that there is a crime going on. The moment he gets out of the car, he smells the odor of marijuana. That is a reasonable suspicion. He is not engaging in asking the defendant for a driver's license. He's not doing a once and warrants check. He does call in the tag because they call in every tag when they stop so that dispatch knows who they're out with. If he ends up needing to fill out a report of a person assist, so they often get information for person assist. If you look at Moran Espinoza, that is actually argued by us in that case, and it is noted by the courts in that case. There are several reasons for permitting a police officer performing a motorist assist to ask for a driver's license. In many cases, police officers are required to make a written report of contacts with citizens. An officer needs to know whom he or she is assisting in the event a citizen later complains about improper behavior or on the part of the officer or makes any kind of legal claim against the officer. So he called in the tag. He hasn't even done anything with a driver's license. He's simply asking him what's going on, checking on the individuals in the car. That is absolutely permissible to make sure everyone is safe, make sure there's not anything that needs help. Often they even offer water or assistance while they're on the side of the road. I just was at an accident scene not too long ago, and I called it in and stayed with the two minor children so that the dad could be helping get his car off the road. The officer in that case offered water, stayed with us. It was an extremely hot day, and I kept the kids in my air conditioning and entertained them so that their dad could be with the officers helping getting his vehicle off the middle of 99. So these things happen. It's very common. The officer's not doing anything wrong here. He stops, he gets out, he talks to the driver, walks up to make sure the passengers are okay, confirms that the odor of marijuana is definitely coming from this car. And at that point, it switches from reasonable suspicion. He's on probable cause. Probable cause is way more than reasonable suspicion on the level of reasons to search. At that point, he does have a reason to change it to a probable cause detention. And he hasn't done anything to prolong the stop other than check on the people in the vehicle. This is a clear case based on all of the case law, which is always changing. And Ellis isn't the end all be all case anymore. There's several cases that have come out since then. There's absolutely no reason to suppress this case. There was a transcript of the preliminary hearing prepared on page 11 of that. It's page 11 of that preliminary hearing. Deputy Fisher's testimony is consistent. He even says, besides the seats being folded down, was there anything else interesting?
All right, just a moment, Mr. Lett. I think you're referring to evidence not presented at this hearing, which the court
Correct.
isn't inclined to allow.
Well, it's very consistent with his testimony. I asked him if his testimony was consistent with his preliminary hearing. It actually starts on page 13 and goes into 11 to 13 when we're talking about the smell, and it ends on page 13. He smelled the marijuana and he talked about it in the preliminary hearing. So this you can see how short this video was. He immediately gets out of the car, smells marijuana, walks up there and says hi. The passengers are backwards in the car. There's a mattress put out over the back seats, folded down, that's been there a while. And so this is a very clear case that there's traffic issues going on and the odor of marijuana for probable cause. Probable cause is a higher standard than reasonable suspicion. I believe this is a clear case that the motion to suppress should be denied.
Mr. Williams, I know that you wish to interject here, but the court's not going to allow it. Okay. Mr. Ambrose, I trust that you have also reviewed State versus Freddie David Moran Espinoza, the
Yes, Your Honor.
case offered by the state as persuasive authority here. Why shouldn't this court follow the rationale of Moran Espinoza?
And Your Honor, I would distinguish it from that Moran Espinoza case in this. That in the Moran Espinoza case, when the driver's license was handed over, the officer had questions to believe that it was a fraudulent driver's license, which is a crime. So the officer had reasonable suspicion arising out of that. In this case, I would distinguish it by the fact that upon Mr. Williams's discussion with Deputy Fisher, and just so we're clear, I want to make sure I'm clear with this portion. When Mr. Williams spoke with Deputy Fisher was out of the vehicle. They were just very close to his patrol vehicle. That Deputy Fisher had walked out of the vehicle, but he was probably at the front quarter panel of his vehicle. They were speaking about right there. And how I would distinguish it is that upon the discussion that Mr. Williams had with Deputy Fisher, I don't believe that there's sufficient evidence that there was even reasonable suspicion of any criminal activity being occurring. Now, I do understand that Deputy Fisher has testified today that he smelled marijuana immediately upon stepping out of his vehicle. However, in the affidavit that we referenced during the hearing, he doesn't reference that in the affidavit until after he goes up to the vehicle itself. And so that's how I would distinguish it from that case that you just referenced.
Very well. Court has considered the persuasive authority offered by the state in the Moran Espinoza case, and the facts are not the same. There are similarities between the fact pattern in Moran Espinoza and the fact pattern here. The court will find in this case that the information available to the officer is that there was a vehicle on the side of the road of a highway, which he describes as a very busy highway. It's clear from the video that it was at night, and that immediately upon arriving, Mr. Williams came back to the vehicle and indeed confirmed that this was in essence a disabled vehicle because they had ran out of gas. Now, he apparently related that other individuals were on their way to bring them gas. The court finds that it was quite legitimate for this officer to approach the vehicle, as this was a legitimate public welfare check, to check on the welfare of not only the driver who came out of the vehicle and approached the officer, but also to allow the officer to approach the vehicle just to check on other possible vehicle occupants. immediately upon approaching the vehicle without any unnecessary delay or unnecessary extension of any detention that may be involved here, he smelled the strong odor of marijuana, creating not only reasonable suspicion, but also probable cause that that vehicle actually contained the controlled substance of marijuana, therefore enabling the later search. The video does confirm, as I think Ms. Gillette argues in this case, that the reasonable suspicion at a minimum, and in this court's view, the higher standard of probable cause was met almost immediately after this approach by this officer was initiated. Therefore, the court will find that this was a valid public welfare check, that the defendant and the occupants of the vehicle had not been improperly detained in any way, that the officer acted appropriately and legally in expanding the welfare check to an investigative detention because of the strong odor of marijuana upon the approach and the almost immediate determination that the motorists were not only in need of assistance, but also that there were apparent passenger restraint violations that had taken place in this case. The court does not find that there was any violation of any Fourth Amendment rights in this case, and the court will deny the motion to suppress evidence for the reasons stated by the court. With this ruling made, we have a pending case with a pretrial conference, 10 o'clock a.m. on November the 6th. Mr. Williams, I'm going to want you at the same location where you are today for that pretrial conference. Again, that's November the 6th at 10 o'clock to be conducted by Zoom, with your jury trial currently set to begin Wednesday, November the 12th. And I am confident, since this is just a 2-day setting that I have available, Ms. Gillette, that you believe that we can start and end this trial within a 2-day period?
I do believe so.
All right. The
I
court
don't
also
believe
has
it.
that confidence.
Yeah, I don't think there's going to be a problem, Judge.
Trial is essentially set to begin Wednesday, November 12th at 9 o'clock, continuing to November 13th as necessary. And Mr. Williams, you will need to be personally present for all stages of that jury trial if it goes at the Greenwood County Courthouse in Eureka, Kansas. All right, Mr. Williams, I had done a substantial reduction of your bond, I think, at our last hearing. You followed through and done exactly what you were supposed to do. I'm pleased that you were able to make that bond and that you've appeared just as the court ordered you to do. You'd be surprised, Mr. Williams, how few people seem to be able to follow the direction of the court. So I'm pleased that you were able to do so, and I give you credit. So I'm going to maintain you under your current bond with the same restrictions as before.
Okay.
Which essentially limits you to 3 counties.
Yes, sir.
And you're
just a moment, Mr. Ambrose. I think I want to hear him out. Mr. Williams?
My attorney, but Chris is, I think he's about to tell you, he better ask you. He's about to ask you the question about that. Yeah.
Okay. Mr. Ambrose?
Yes, Your Honor. I was able to speak. I was speaking with Mr. Williams earlier this week, and he had asked if I would request the court to modify the conditions of the bond to allow the removal of the electronic monitoring on him at this point. Mr. Williams is the electronic monitoring is a financial burden for him, and it's providing troubles, and he's shown that he can be out and do what he needs to on bond. We'd ask that the court would contemplate allowing that modification for him.
Mr. Williams, what kind of work are you currently doing?
I'm doing construction. Actually, I'm doing work around the house and going with my auntie and taking her to an area. She's taking me to an area to help her out, and she's behind me now actually. So it's kind of hard for us to get around for me to help her out. Certain areas that she has to go to. Like certain areas that she goes to, like Hutchinson, where else you be going? Chanute, like that, and I can't attend to her at that time because I'm on monitor. Other than that, that's about it,
Does the state take a position on this request?
I was looking to see if you had any recent failures to appear. I'm not seeing too many. So he has showed up today, Your Honor. I was looking, let me see. I'm okay with removing the GPS unless his bondsman wants it. Sometimes bondsmans keep it on as part of their contract. He is supposed to be Allen, Woodson, and Greenwood County restricted, and not to leave Allen to be at courthouse for all hearings. I don't know when he mentioned Chanute, Neosho County's next to Allen County. So yeah, that is a place that's close by there. So if you want to remove it, I'm fine with that. But he just needs to be here.
I will.
Mr. Williams, you're not going to take off on me, are you?
No, no, sir. No, sir. I won't.
Well, that's a good answer.
No, sir. I won't take off on you. I'll be here.
Well, I think your good faith and your timely appearance today speaks volumes, Mr. Williams.
Thank you, sir.
I'm going to remove the restriction regarding having a location monitoring device at this time, Mr. Williams.
Thank you, sir.
There's other places I think in your life you need to be putting that money. Would you agree?
Most definitely, sir. Most definitely.
Do you know when you need to be at the courthouse in Eureka again?
November the 11th?
No.
I didn't write it down. Let me write it down. November the 6th.
And what time? It's 10 o'clock in the morning, Mr. Williams.
November 6th.
I'm sure Mr. Ambrose would have reminded you through some communication, but it's November 6th at 10 with you being right where you are today.
Yes, sir.
All right. Counsel, I trust there may be some discussion that will take place between counsel between now and then in good faith with some possibility, perhaps, that there might be some agreed upon disposition of the Williams matter.
And Your Honor, I'll tell you that I'll talk with Mr. Williams after today's decision and we can game plan what that might look like. And then I'll engage with Ms. Gillette as appropriate.
Thank you, Mr. Ambrose. Appreciate those efforts and Ms. Gillette's negotiation in good faith. All right, very well then. If there's nothing further at this time, the Robert Lee Williams matter will currently be in recess, and this meeting may be ended for all. This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Wayne Allen Moeller. It is case number 2024 CR 140. Chris Ambrose appears as defense counsel of record, Jill Gillette as Greenwood County attorney. Wayne Moeller appears from the Lyon County Jail. This matter comes before the court at this time for sentencing proceedings at this time. According to the pre-sentence report in this case, on July 11, 2025, Mr. Moeller pled no contest to an amended count 1, unlawful distribution of a controlled substance, a level 4 drug felony, and count 5 as charged. Count 5 being criminal carrying of a weapon, a level 9 non-drug felony. A pre-sentence report was ordered and sentencing set for today. Court has received a pre-sentence investigation report compiled by Tony Bauer, pre-sentence investigator. I trust each attorney has received a copy of this report. But before we go any further, it's the court's understanding that there may be a motion for counsel's withdrawal before the court. Mr. Ambrose?
Yes, Your Honor. Mr. Moeller and I were able to speak last week, I believe, and go over some things. He's in Lyon County on an unrelated issue. It is Mr. Moeller's desire to pursue withdrawing his plea. As a result of that, I believe it's appropriate to have new counsel appointed so they can fully investigate any issues. I, as defense attorney that handled that plea, is not appropriate for me to stay on there in case that counsel determines that there's any claims that could be raised against trial counsel who worked on getting that plea taken care of.
All right. Mr. Moeller, you're wanting to withdraw your plea that you entered in this case?
Yes, sir.
All right. All right. Mr. Ambrose, you're taking the position that you can't pursue this motion to withdraw his plea. And that's because there's going to be an allegation that you didn't do your job?
Well, Your Honor, and this is how I've seen it widely handled in the jurisdictions I practiced for years now, is that when a motion to withdraw is pursued, new counsel is appointed. So then if there are concerns about any ineffective assistance, that can be raised by subsequent counsel.
All right. Of course, I don't care about how any other jurisdiction does anything. I care about this case right now. Mr. Moeller, give the court, this is not going to be a secret at some point. If you're going to file a motion to withdraw your plea, what is it based on?
Judge Levin has been an attorney of mine in a previous case, and I don't feel like I've seen all the appropriate evidence. And we had talked about having in the plea agreement. I've never even seen this plea agreement that you accepted. I've never seen it on paper.
Okay, was there a written plea agreement drafted in this case?
No, Your Honor, we did
Okay.
an oral plea like we traditionally do in this jurisdiction.
Okay.
I don't know the terms and conditions of the plea, and I was told that in the plea I would be eligible for drug court, and that has not been even brought up.
Okay, the 13th Judicial District does not have a drug specialty court, so.
Okay. I know that Jill Gillette has been an attorney in the previous case, and should be a conflict of interest in there.
Okay, Jill Gillette has been your attorney in previous cases?
Yes.
Okay, well, you're not asking to have her removed from the case or disqualified from the case, are you?
Yes.
I don't remember ever representing you.
And Eureka in Woodson County. Or Woodson County.
Why wasn't this raised before? I mean, she's not new to the case.
I didn't even know it before. I knew, but I didn't realize it until previously.
Are you sure it was me and not Jill Chard?
No, it was you.
Because I don't have any record of you in my conflict check. None. I maintain my own old electronic system so that I can make sure whether or not I have a conflict check. And you're not in there.
Well, that's an entirely separate issue, but one that may need to be resolved before sentencing. We're just awfully far along on the case, Mr. Mueller, before you raise an issue about some sort of conflict on the prosecutor's part. Because again, she's been at this case from the very beginning.
Right.
Your Honor. Are you somehow suggesting that Mr. Ambrose hasn't done his job properly?
Yeah, I haven't. Like I said, I haven't even seen this plea. I want to read the terms and conditions of the plea agreement that I accepted, and there was never one given to me.
All right.
I've never signed the plea agreement.
All right. Well, Mr. Mueller, I know you probably remember this. A couple of months ago, you were before this court, and there was a long question and answer session that the court did with you before I ever accepted your plea. You didn't seem to have any problems with any of this at that time.
Yeah. I just heard the plea like a minute before we even got in there. I didn't even realize what was going on at the time.
All right. It is difficult for this court to find that Mr. Mueller at this point has justifiable dissatisfaction with his current attorney, Mr. Ambrose. But in an abundance of caution, I'm going to presuppose that there may be some legitimate reason here for him to be critical of the way his attorneys handled his case. Furthermore, the court believes that we're going to need to set another hearing in this case if indeed that you can have new counsel file a motion to withdraw your plea, that it'll have some basis. And there'll need to be a hearing on that. I'm going to go ahead and reset this case for further proceedings for Thursday, October the 9th at 3 o'clock. October 9, 3 o'clock p.m. Mr. Moeller will need to fully participate. What is your status there in Lyon County, Mr. Moeller? How long are you going to be there?
Till December 25th.
Okay, you're serving time for that county?
Yes.
Okay, all right. So
And-
we should know where to be able to find you.
I looked up his county cases. They're in 2022. I was the prosecutor here by then, and Ms. Jill Chard was his attorney, not me.
Okay.
And then she was withdrawn and he got someone else.
All right, so noted. Mr. Ambrose, I think under the circumstances, the court's going to allow your withdrawal.
Yes, Your Honor.
New counsel will be appointed. Yet to be determined who that will be. I'm sure they'll contact you in due course, Mr. Moeller, at the Lyon County Jail or in some appropriate fashion. I will expect that diligence will lead to a timely filing of a motion to withdraw a plea if indeed that's what you want to do, or that counsel can see you through with the sentencing that we had set for today. You need to visit with a new attorney and determine an appropriate strategy under all the facts and circumstances of your case. So sentencing or further proceedings in the case will determine exactly what those are when we get there. For Thursday, October 9, 3 o'clock p.m. with Mr. Moeller participating by Zoom. And Chris Ambrose is allowed to withdraw his counsel, and a new attorney will be appointed by the court. All right, Mr. Ladd, at least at this point, I don't have any legitimate grounds to believe you should be disqualified from further handling the case.
No.
So I presume you'll be there October 9th with us. All right, thank you for your work on the case, Mr. Bauer. And your appearance today, Ms. Stanfield, on behalf of Community Corrections, but we'll have to defer sentencing proceedings to a later date. Possibly October 9th. It could be beyond that, depending on what happens. All right, Mr. Ambrose, is there anything you need to address the court about?
No, Your Honor. Thank you.
Mr. Ladd, anything you need to address the court about at this time?
No.
Mr. Moeller, do you understand what we've done here today?
Yes.
Okay. All right. I'll just expect you to fully cooperate with new counsel once that new attorney contacts you. Okay.
Okay.
All right. If there's nothing further at this time, then the Wayne Moeller matter will be in recess, and this meeting may be ended for all. Thank you, Judge.
B. Blake Berkeley, 01542. This is people of the city of Berkeley versus Larry David Kaufman. Your appearance, please, Mr. Mitchell.
Ready, Your Honor. Michael G. Mitchell on behalf of Mr. Kaufman, who is present via Zoom, and we consent to say, Mr. Kaufman, please state your full name for the record.
Larry David Kaufman.
Your Honor, at this time, I'd waive any formal reading, stand my client mute, ask that a not guilty plea be entered. I have advised him of the charges and the maximum penalties and all of his rights therein. He would be requesting assigned counsel.
Thank you very much. Mr. Kaufman? Yes, sir. The court sees that you're probably not too familiar with criminal procedure. This is arraignment only. So the court's entering a not guilty plea on your behalf. Repeat, not guilty. Okay? Court-appointed counsel is noted and approved for the future. So that's good. So if you make your freedom today, you'll be getting mail to the Franklin address that will direct you when and how to participate in a pretrial. And before that occurs, you'll be hearing from counsel. They're going to want to team up with you and make a plan as to how you're going to move through this case. So if we're good so far, the next thing the court needs to consider is the issue of bond. You might have heard that referred to as bail sometimes. That's not intended to prejudge or punish you. Our constitutions tell this court that you're presumed innocent, but the court must set bond to ensure that you do reappear and to afford any necessary protection for the public. Mr. Mitchell, there is a bail recommendation from Community Corrections that suggests release. However, one of the citing officers is present, and officer, please put your remarks into the record, and then Mr. Mitchell will speak to the court as to bond. Yeah, Your Honor. So in regards to the event that happened yesterday and at the above listed date and time, I just wanted to clarify a couple things regarding the incident in general. Mr. Kaufman has threatened and intimidated the witness statements, as well as the statements, the verbal statements they gave us at the time and the date. I'm requesting that the court consider a no contact order for Miss Bernadette Thibault, who lives at, which is a neighbor directly next door, as well as Virginia Earl, who lives across the street at. They're both elderly females and both live alone, and this gentleman's actions have caused him to make them fearful of their physical as part of bond conditions. Thank you. Is there anything else you wish the court to know, officer? That the only thing that, based on their witness statements, that they felt physically and verbally threatened at times, with video footage of both occurrences from just yesterday. And it seems that there's a long history regarding these actions taking place against these two women. Being a police officer's job is to take care of these residents, and I want to ensure that I do everything I can to make sure that their mental well-being is taken care of. Very well. Mr. Mitchell, what do you wish to share?
Your Honor, my client is 74 years old. He's retired. He's indicated to me he's got no prior criminal history whatsoever, nor any FTA history. I believe that the court said there was a recommendation from pretrial services for a personal bond. I don't think he's a flight risk or a danger to the community. I can't speak as to the history regarding the named individuals, Your Honor, but I think a personal bond with the appropriate conditions would be appropriate.
Thank you very much. Mr. Kaufman, you're in a manageable spot here, but
Yes, sir.
You're in the driver's seat, okay? Hear the court out. These are the rulings of the court. You will appear as you're directed for all your future dates. You'll abide any valid order or judgment entered in this case. Do not leave the state of Michigan without permission of the court. Do not commit any crimes on release status. You will notify the court in writing of any change in your contact information. Mr. Mitchell, we're going to indicate making reports to pretrial services at this juncture, check-in only. The court is ordering no use of alcohol, marijuana, or any other controlled substance, but the court will not impose a specific testing regimen at this time. No purchase or possession of a firearm or other deadly weapon. Now, you will not assault, harass, intimidate, beat, wound, or threaten Rosalind Newberg, Jan Newberg. This looks like Ivan Renenkovich. And officer, you had a couple of additional names that you were concerned about? Yes, Your Honor. It's the two victims from yesterday's alleged assault. One's Bernadette Thibault, Theboldt. She lives at the neighbor directly west of this gentleman's address. The other one is Virginia Earl. Virginia Earl, E-A-R-L. She lives in the city of Berkeley.
Excuse me, may I comment, sir?
Sir, we're not having a trial today. We are just considering issues as to bond. So nobody's finding you guilty of anything. You're presumed innocent. but the court has broad statutory discretion to consider what conditions of bond are necessary to make sure you do return to court, that you pose no threat to the public, that the peace is kept in the city of Berkeley. The Berkeley is a city that is known as We Care. Okay, so the court is indicating no contact with the aforementioned Newbergs, Mr. Renenkovic, Bernadette Thiebold, and Virginia Earl, nor will you have any contact with any of those 5 individuals, direct, indirect, or through a third party. That means no phones, no phone calls, no messages left on front porches, nothing in the mailbox, no U.S. mail, no carrier pigeon, nothing. No contact means no contact. You will not enter.
Mr. Kaufman, let the court finish.
No threatening or assaultive behavior toward any person. Mr. Kaufman, what is it that you so desperately wish the court to know?
All right. Sir, it's probably not significant. I just want to, for the record, the 3 people, not the resident next door to me.
Mr. Kaufman, I don't think it's a good idea to go down to say anything further. Let's let the court finish.
Mr. Kaufman, the facts that you might be trying to bring to light right now are facts that appear to involve the exact time frame where the allegations are stemming from, and that could incriminate you. You do not want anything in this court's record that could be used against you at a later hearing. Is that sufficient, Mr. Mitchell?
Yes, Mr. Kaufman, no more from you today. Let's let the court finish. It can only get worse from here. Do you understand?
So what the court is doing at this time, Mr. Kaufman, is setting
I understand that.
a $10,000 personal bond. What that means, Mr. Kaufman, is that you are on your honor that you are going to obey all of these bond conditions to the letter. You do not need to post $10,000 to go home today. However, if you miss court dates, violate bond conditions, you contact any of those 5 people, you go to any of those 3 addresses, I can almost foresee and assure you that Berkeley Public Safety will be in your driveway and we'll be having a bond violation hearing, and you'll be sitting back on that bench and then perhaps up to the 1201. Nobody wants that, okay? So we are on our honor. We're all going to conduct ourselves as gentlemen. It's a $10,000 personal with the aforementioned conditions and pretrial service check-in. Anything further, Mr. Mitchell?
No, thank you, Your Honor.
Anything further from the people? That's you, officer.
No, Your Honor.
Thank you very much. Good luck. Calling case number 25, P Light Parking, 178162. This is People versus Sean Lowe Desai. Is Sean Lowe Desai available? This is People of the City of Royal Oak versus Sean Lowe Desai. That's you, sir?
Yes, it is. Yes.
Mr. Desai, the court believes you were present a bit ago when it explained the nature of informal hearings. True?
Yes, correct.
And so you understood the court to instruct that you must select from one of 3 options to protect your rights, correct?
Yes.
Thank you, Mr. Desai. The citation before the court is obviously, as the court previously stated, civil in nature. It does indicate that on July the 7th, a vehicle plated to you or a member of your household entered spot 2910 on 4th Street, City Royal Oak, at 7:11 in the evening, exited at 9:14. The total park time is indicated as 2 hours, 2 minutes, 19 seconds. There was a payment, Mr. Desai, of $1.75. That purchased 1 hour and 10 minutes of time. So the citation is obviously for overtime at meter. You may admit responsibility. You can admit and explain, or you may deny responsibility, and we will swear the parties and take testimony. Mr. Desai, what do you wish the court to do?
I wish to admit with explanation.
Very well. So you're confirming to the court that on the date in question, a vehicle plated to you or a member of your household was parked as stated and or stationary, but insufficient in full payment for the time it was there, correct?
Correct, yes.
Thank you. The court accepts your plea. What's going on, Mr. Desai? What do you want the court to know?
Well, I just wanted to submit to the mercy of the court here because I usually rely on the notification to extend. There's a warning and an opportunity to extend the parking, and I failed to either notice it or pay attention to the warning. I'm assuming I got it because I would think that it's automated, but in any case, I failed to extend it. And so I was wondering if there would be any, mercy available in this instance, as for that additional time that I was parked there.
Fair statement. Do you frequent that central business district often?
Yes, Judge. I believe that is that near Ronin Sushi?
Sure is.
Yes, that's exactly where I was. I was at the Ronin Sushi. I go there relatively often, and now I've realized I'm not the best at keeping track of the app, so I just park in the parking structure now.
Way better plan.
Yes.
Yeah.
And cheaper too.
Yeah. When 2 hours for free. Can't beat it. Anything on behalf of the people? Officer Fraser.
Nope. I'm all set, Your Honor.
Okay, what the court's going to do in this instance, Mr. Desai, is we'll just roll back the clock very briefly to 1986. Your fine is $5. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday to Friday between 8:30 and 4:30. That's due within 14 days. That completes your hearing. Good luck to you.
Very good, Judge. Thank you. Have a great day.
Oh my. It's almost like Judge Eric, Magistrate Eric, had to stifle a little bit of a laugh there. I don't know if you saw him where he was. It was funny. I thought that was hilarious. That's how we're ending it on a light note. $5 fine. The city wants its $5. Thank y'all for hanging out. It's been a hilarious chat. It's been great. I hang out and do live chats every night of the week. I don't know if y'all know that. Come by. It happens around 8 p.m. Central Time. That's 9 p.m. Eastern Time. Come on by, chat with us. We do pretty much what I call a daily case review. It's not necessarily alive exactly like this, but it's close enough to what we do here. But these videos, as usual, are videos that I'll probably cut up later on and release later with the comments on them to the people who might not have been here for the live and might be interested in seeing what people were saying about the cases of the day when they were happening. Ladies and gentlemen, I'm your Lolo Fusel. I'm your curator for these here videos here on this channel, and I am your host for this here weekend case review, and I am done. I'm done. I mean, I have more I could play, but we've been here for 2 hours. I think we all have other things we need to do. It's Catterday. Go out and enjoy your day. I'm done. Thank you all for coming out. I can't read names fast enough. Carla, Alan, Eileen, all the usual suspects, Rhonda, Mama. Thank you, Mama, for being here. I'll see you all next time. I am your Lone Fusel. I am out. And don't be expecting surprise after show pop-ups all the time, every week. It's just not going to happen. One day. Not today. Thank you all. Love you. The puppies say bye. So does the cat. He wants food. So do I. Have a great day. Bye.